Hearing the appeal MacDonald and another against Carnbroe Estates Limited.
Yes, Lord Davidson.
Lords, good morning. At the heart of this appeal is the proper interpretation of adequate consideration as provided in Section 242(4)(b) of the 1998 Act. My primary submission is that the Inner House set the bar too high for the test of adequate consideration. The Inner House took as its starting point the content of what it described as the principles of insolvency law, this starting at paragraph 14 at MS 77 of its judgment. In particular, the division identified the second principle or critical feature as being, I quote, if a debtor alienates property once he is insolvent, he must obtain full consideration, I stress full consideration, for the property alienated. Now, what we say is that where the division misled itself is when it translated that principle into the terms of Section 242, and this at paragraph 30, MS 87. There it required an attempt to, and I quote, to sell the property, and I stress this, for its full market value, assuming a willing buyer and a willing seller, and without any time constraints. I'll use full open market value as a shorthand for that formula. Now, it was on that basis that the £550,000 price was rejected by the Inner House as not being relevant and thus failing to qualify as adequate consideration. Now, what we submit is that the error by the Inner House was to interpret adequate consideration generally as full open market value. This imposes a meaning on adequate that is very close objectively to best price obtainable on the open market. So that's going way too far. Now, the term adequate is suggested means something less than best price or full price, suggestive of satisficing rather than optimizing what is satisfactory in the circumstances. What it does not suggest is that the market value ideal of an open market with willing buyer, willing seller operating without time constraints applies. Had Parliament decided that it wanted a test to that effect, it could have used different language. If it meant full open market value, it would have used different language. The choice of adequate, we say, is to permit a flexibility rather than any specific formula. Now, market value is a term not unknown to the parliamentary drafters. It appears in Finance and Tax Acts, and now following amendment by the Enterprise Act 2002, it appears also in the Insolvency Act 1986. This at Schedule B1, para 111, which sets out a definition of market value. Now, I apologize, that is not set out in the authorities, but my junior has copies of that if the court would wish to see that particular provision.
Yes, that might well be helpful.
This contains a definition of market value. The photocopy that's been given to my lords starts with the Enterprise Act, and then there are a couple of pages showing that it's amending the Insolvency Act 86.
Thank you.
And the fourth page of the photocopy sets out interpretation. Now, this is all to do with administration, so we're in different territory from the particular issue in hand. But one sees at 111, subpara 1, market value means the amount which would be realized on a sale of property in the open market by a willing vendor. Now, that's slightly different terminology from that deployed by the Inner House. It doesn't refer to willing purchaser, it doesn't use the term fool, but it does indicate how Parliament, when it requires to refer to market value, can do so quite easily and has done so. It did not do so when it shows the formula adequate consideration. Now, the cases themselves, I submit, provide some, but not very much, guidance in the content of adequate consideration. Case of Lafferty, that is authority number 5, and this is Lord Cullen, Walls, at MS 317. And letter C, His Lordship observed, in considering whether alienation was made for adequate consideration, I do not take the view that it is necessary for the defender to establish that the consideration for the alienation was the best which could have been obtained in the circumstances. On the other hand, the expression adequate implies the application of an objective standpoint. The consideration should be not less than would reasonably be expected in the circumstances, assuming that persons in the position of the parties were acting in good faith and at arm's length from each other. That does indicate, if His Lordship is right there, that it is not necessary to have the best obtainable in all the circumstances, this in the context of adequate. That seems to be slightly at variance with the approach that the inner house seemed to apply as the generality. And the not less than reasonably expected in the circumstances, again, is a fairly broad formula. My submission is that neither of these formulations support an interpretation of full open market value.
Do you put forward what Lord Cullen is saying as an acceptable definition of adequate consideration, or are you qualified in your support for him?
I accept that definition. It doesn't perhaps go the full way, given the way in which the argument developed in front of the inner house. So I will look at the way in which the inner house sought to analyse the position. Of course, they did have the Lafferty case in front of them.
Yes, they did.
That does seem to pose this oddity of how, nonetheless, they came up with full open market value as the test.
But as a gloss on the statutory words, you don't take issue with it?
Lord, no. The way in which the inner house sought to analyse the position was to focus on what it termed forced sales. The description of forced sales is found at para 43, MS 82, and that states forced sales as being productive of a price, and I quote, less than full market price obtained through an ordinary sale in the open market without an element of compulsion. This seems to be simply an alternative formula, less than the formula they're deploying of full open market value.
I'm sorry, which paragraph was that?
At 23, my lord, at MS 82.
Lord Davidson, I'm just about hearing you, but struggling to do so. Could you speak up a bit?
I will endeavour to do so.
Thank you.
I apologise. Now, that particular formula is no doubt correct as far as it goes, but the inner house does not recognise, in the context of insolvency, that sales of assets at less than full price is not only unknown, but indeed is more likely to be the norm in insolvency situation. So the inner house's question at 23, which is to the effect, is the circumstance of a forced sale a factor in assessing the adequacy of consideration, receives from our side, certainly, the answer, of course. Insolvency is usually about running out of liquidity. It is a circumstance that, as like as not, obliges or forces sales of assets. Be that as it may, the inner house at 25, MS 84, divides forced sales into two types. One, those where the business is about to come to an end and where there is therefore, they say, no need to provide immediate liquidity. And separately, the second possibility, the exceptional position, where the forced sale is to protect the interest of creditors, the example given being to avoid formal insolvency procedures. Now, this division of forced sales suggests sale at any discount to full open market value where a business is failing the normal position will fail to qualify rather, as adequate consideration, with the result that the sale may be set aside. The alternative, the exception, the sale at a discount to protect creditors, is perhaps not easy to understand the way in which it is formulated by the Inner House if there is in fact no insolvency, unless the division had in mind the matter of technical insolvency. Now, that alternative rests on whether the sale is to maintain the continuation of the business, this at para 25 MS 83. And that, of course, raises the question about how the prospects of maintaining the business are to be gauged by the purchaser. At para 26, MS 84 to 85, the Inner House states assessment by the court, and also presumably by the purchaser, must be given to whether the business in question is viable, their word, is viable or not. Now, this may introduce another component in assessing whether the consideration is adequate. Thus, a sale at a discount to full open market value by a business that is viable is acceptable on this theory. The sale by a non-viable business fails to meet the adequate test and therefore falls to be reduced. But history, and of course even recent history, is full of examples where businesses thought to be viable turn out, of course, not in fact to be the case. But the consequence of this division seems to be that adequate consideration will vary with the prospects of the company, which might seem a surprising interpretational approach. This analysis by the Inner House all stems from their statement at para 25, MS 83, that for policy reasons in insolvency, paramountcy is given to creditors' interests. Now, we as appellants challenge whether this is correct as a general principle, as between the creditors and a purchaser. There's no particular virtue as between the creditor and the purchaser, we argue. One can see that today's creditor may be yesterday's vendor at an excessive but as yet unpaid price. The flaw in the Inner House's approach is to assume the paramountcy of creditors' interests in the sense that anything less than full open market price undermines their interests. The use of adequate, we say, suggests a balance operates between the creditors and the purchaser rather than paramountcy of the creditor's interests. The flaw in the reasoning is to impose far more weight on the word adequate than it properly bears. The correct approach, we say, is to recognize that creditors have protection to the extent an adequate consideration is paid, but so too the purchaser is given protection of the transaction if it has paid adequate consideration. So a balance operates between the creditors and the purchaser rather than paramountcy for the creditor's interests. So imposing proof of full open market value on a purchaser to preserve a transaction is not objectively reasonable. It's too high a bar that the language does not support. The purchaser, of course, is not made a trustee for the company's creditors by way of Section 242, or nor indeed by the common law, but that seems to be underlying a lot of the reasoning, not that it's the purchaser, but that it's the company is the trustee. So accordingly, we submit that the Inner House was in error in its approach to adequate consideration. The correct approach is more flexible and more responsive to the circumstances of each case, what is reasonably satisfactory in the circumstances. Furthermore, if one looks at the practicalities, they urge such an approach to the language. The division's approach would present a considerable task for any prospective purchaser. The prospective purchaser, in order to protect the purchase, would be required to assess the viability of the vendor's business, assess whether the business is heading into insolvency, whether the sale is forced but may nonetheless preserve the business, and depending on these assessments, the sale may or may not survive being reduced, set aside by the court. So complex calculations, and hence considerable risk, would be transferred to the purchaser by such an interpretation that the Inner House adopted. That task, of course, is not made any easier by the terms of Section 2423 that permit reduction of sales over the 2- and 5-year periods prior to any winding up. So one has to have a capacity to assess the future as well. Now, presumably, such an approach, to be coherent, would have to apply to all sales. And one can see that in this particular case, there's a very large asset being sold, but presumably any sale of any asset would have to meet this particular test. Among the substantial difficulties with such an approach, there are also circumstances which challenge the view that full open market value is the correct measure of adequate consideration. An early sale at a discount, as here, may avoid accumulating debt. Again, as here, an early sale at a discount avoids uncertainty. Markets, of course, fluctuate. There's not a specific price or range which can be said to be the full price that will, in fact, be achieved over what here seems to be a 24-month period, 24-month marketing period, that is. Also, an early sale at a discount avoids the costs of prolonged marketing. And the commercial judge recognized the value of a quick sale at 31 MS 103, where he went through the particular factors applied here. Therefore, were adequate consideration to be full open market value, these impractical results would flow. So accordingly, we submit that the better interpretation of adequate is to be satisfactory in the circumstances, the broader approach. Now, when one then turns to the present case, the commercial judge noted at 27 MS 102 that neither of the parties' expert witnesses, and I quote, would have raised an eyebrow at the price of £550,000 in the circumstances and having regard to marketing costs and an estate agency fee. So the commercial judge identified that particular point, and he found that both experts, the pursuer and the defender, as both careful and measured witnesses. This at 22 MS 100. Both expert surveyors agreed a discount of 25 to 30% would be acceptable if marketing were restricted to 6 months. Arithmetically, £550,000 falls within the range the surveyors regarded as professionally acceptable, this 24 MS 101. I've done the arithmetic to this effect, it may be correct. If there is a 25 to 30% discount applied to the range of 820 to 740,000, that would produce a discounted range of 595 to 528,000 pounds. Thus, £550,000 turns out to be within the range the experts' open market price, willing buyer, willing seller, but subject to a 6-month marketing period, turned out. Now, a 6-month marketing period, I would respectfully suggest, would be within the sort of time that a liquidator or indeed a lending bank might fix for disposal of assets. It can be a reasonable approach in the circumstances of insolvency. Now, the respondents argue that the urgency of the sale requires to be justified in the circumstances. We say that's neither here nor there. There isn't a requirement to so justify because the expert evidence places the consideration at a level a 6-month marketing period would obtain, and a sale over a 6-month period would not be an urgent sale. Put it another way, the evidence does not show an actual 6-month marketing period would have achieved a better price. Accordingly, we submit that £550,000 falls within adequate consideration, assuming that our interpretation of that term is correct. The remaining matter is a further argument advanced by the respondents, and this in their case at MS 59 to 60. And these challenge the bona fides of the transaction and whether there was payment of the true consideration. As regards the bona fides argument, we say this is argument by innuendo. Neither of Messrs. Gaffney and Quinn were cross-examined, their evidence being taken by witness statements. Nothing in the statements, we say, suggests the transaction was other than bona fide. And indeed, I refer back to the point about the experts. They say they would not raise an eyebrow at this transaction. That doesn't suggest that there was, putting it colloquially, something funny. As regards consideration, £550,000 was the legally enforceable consideration. True, there was delay in payment of the balance, but that doesn't alter the fact that the consideration was 550 and ultimately was paid.
What was the explanation in the evidence about that curious failure to pay the balance of about £75,000, Lord Davidson?
There wasn't an explanation.
None at all?
The payment was being made. So the counsel who appeared before the judge at first instance said the balance is going to be paid.
I know, but what was the explanation for the curious failure to pay over, was it almost 2 years?
Indeed. If I were to speculate, and it
What was the evidence, is the question.
there wasn't evidence.
I see.
It wasn't investigated.
No. And who's the onus on in respect of the overall adequacy?
Well, the onus, of course, is on the appellant.
Very well.
We say that that was established by the expert evidence.
And it slightly puzzled me, but reading Lord Woolman's judgment at 29 and 30 on MS 102, it seems that the defence advanced by your clients at that time, and I appreciate, Lord Davidson, you weren't involved, was that Grampian was fighting for its survival. And in 30, Lord Woolman says it could not afford the leisure of a lengthy marketing period. Am I right to assume from that, and of course we haven't seen the pleadings where the defender set out his case, am I right to assume from that that contrary to the arguments that seem to have been advanced in the inner house, the defender was resting its case on a fight to survival? We needed cash to get liquidity.
That certainly was the position.
That was what the defence was.
That is what the company thought it had to do. There is the witness statement of Mr. Quinn, and that, I think I gave reference to that. He sets out his explanation of how he saw the position. This at some length. This at MS 111 to 113. He identifies that the company had fallen into cash flow problems at 3. He notes the problem of bringing the property up to scratch, as he put it, at 5. And then at 6, last two sentences, it seemed to me that the best way to deal with the situation was to find a buyer rather than allow it to be repossessed. If the yard had not been sold, it would have been repossessed. I had some idea of the market for yards like the company's. It was not particularly valuable because of the problems and so on. And that's why he then continues quiet in relation to the quick sale at 9.
Yes, I have read the affidavit, and I can see from that there was a cash flow problem once the debt factoring agreement was cancelled. This is a distribution business. He then disposes of the trucks, and he then proposes to sell the principal distribution depot. This is not really consistent with what seems to be the pleaded case, that the business was fighting for survival as a business.
Well,
there could have been a defence argued that, hang on, the options facing the company were a sale by the standard security holder or a liquidator, and there could have been expert evidence that would have depressed the price, but there wasn't such evidence, was there?
But what there is at para 9 of Mr. Quinn's statement is that he says that I didn't think that was a very good price, this is the 550, but it was as good as I was going to get given that I needed a quick sale before arrears built up. So the question of the bank interest was unmet, and the bank was pressing. So he had that position. There was no evidence that there was going to be a higher rate as arrears built up, but there were certainly arrears building up. This was a way of clearing out the secured creditor for its entire debt.
Yes, but he was negotiating with a man who had offered informally £900,000 several months before, and the arrears were accumulating at £4,600 a month.
Although, well, it's entirely correct, he'd offered 950, but that was not a proper offer.
No, it was an indicative offer.
Well, who knows what it was, but there was certainly, when it comes to the evidence, one has the expert's view that had the appellant paid 950, they'd have been overpaying. My Lords, unless there's anything further, I would urge my Lords to allow this appeal.
I had one minor question. Can I put it? Would you go to 108, please, in the bundle, Lord Davidson? I think these are agreed facts. And I think the last one, if you've got AA, is that a policy of insurance has been obtained by the defender in respect to the property, and the sum insured in respect of damage to the property is £3,450,000. Was there any evidence about when that policy of insurance in that sum was taken out?
No, I don't have an immediate answer to that.
Of course, one must make allowance for the fact that certain expenditure following purchase will have been made on the property. Nevertheless, it's quite an arresting figure, isn't it, Lord Davidson?
Oh, of course, but it's for reinstatement.
Yes, quite.
Yeah, so
Fine.
inevitably. I mean, the solid ground is the expert surveyor's view of what value is. So whether it's 3.45 or whatever, the reinstatement value I submit is neither here nor there when it comes to adequate consideration.
Very well, thank you.
Apparently, I'm told it was also for the contents, quantum valeat. Unless there's anything further, my Lords.
Thank you very much, Lord Davidson. Mr. Brown, do you follow?
Thank you, Lord. I have nothing to add.
Mr. McBride.
Thank you, my Lords. If I might start by making four general observations regarding section 242, and I hope that your Lordships might forgive me if some of these appear to be somewhat elementary, but I emphasise them because in my submission they bear emphasis, because in my respectful submission they underpin the issues which are at stake in this appeal. The first is, I think, the uncontroversial submission, which is to say that the purpose of section 242 is to prevent the diversion of assets away from a company's general body of creditors. And of course, I emphasise the general body of creditors. And in that context, I think it's also uncontroversial to say that the general principle which lies behind the section is that from the moment of insolvency onwards, the debtor's funds are no longer his own, but must be managed in a way so as to protect the general body of creditors. I think your Lordships barely need authority for that, should they wish me to direct them to it in the Scottish context, Bell's commentaries. Somewhat more recently, that's at MS 372 to 373. Somewhat more recently, the same point was made by my Lord Hodge, together with Lord Toulson, in the case of Bilta UK Limited against Nazir, paragraphs 123 to 124, MS 607 to 608. The second observation is that Scots law has taken that principle further, because what it has done is it has placed the burden onto the recipient of the property to demonstrate a defence to a qualifying alienation. And by doing so, it effectively places the burden onto the recipient. It advances the purpose of protecting the creditors in the circumstances. In other words, plainly, the liquidator may need do no more than prove that there was an alienation within the qualifying period. Thereafter, everything falls upon the recipient of the property. The third submission I make by way of general observation is that in my submission, the term adequate consideration implies an objective standpoint by which the consideration is to be measured. Your Lordships have already been directed to the dictum of Lord Cullen then sitting at first instance in Lafferty Construction Limited against McComb at MS 317, and I also align myself with that as a proper explanation of what is expected by way of adequate consideration. And I particularly emphasise that Lord Cullen, I needn't, I think, take your lordships to it unless they wish me to, but he expresses the view that it implies an objective standpoint. The consideration should be not less than would be reasonably expected in the circumstances, I emphasise in the circumstances, assuming that persons in the position of the parties were acting in good faith and at arm's length from each other. And in my submission, it's hardly surprising that the statute, which seeks to protect creditors, should express the test in an objective manner. It would be surprising if one were to look to the subjective views of the seller and the purchaser in order to test the adequacy of the consideration. And in my submission, it is also hardly surprising that the court, at least as a starting benchmark, should take the open market value as the test by which to measure the consideration which is actually achieved, because that would be the normal expectation, and creditors are being protected against the possibility of a sale under value. It is, of course, for the recipient, in this case the appellant, to plead any circumstances that they wish to rely upon, should they seek to establish that the price should be somewhat less than market value and should still be deemed to be adequate. The fourth general observation I make is this, which is that the term adequate consideration, in my submission, carries within it an inherent flexibility. It is an open-textured phrase. It recognises that an assessment of whether consideration is adequate or not will be required to be undertaken by the court in relation to a very wide variety of circumstances. It provides sufficient flexibility to permit assessment of the multiplicity of circumstances which the court will inevitably come across. And despite the fact that the court may frequently take open market value as a starting point, it permits an assessment of when a consideration in return for the alienation may be considered to be adequate, even though it falls below market value, because there may be particular circumstances which justify a reduced price. And a moment ago, when I was drawing your lordship's attention to Lord Cullen's dictum in Lafferty, I emphasised the words "in the circumstances," and in my submission, that takes account of precisely that point. The open-textured phrase allows the courts to take account of all of the circumstances in order to determine whether or not the consideration is adequate. Now, if I might just seek to develop that last point about the flexibility by reference to some of the themes which the First Division cover in their opinion. And the point which I make is that there is nothing said on behalf of the respondent, nor was there anything said by the First Division, which in any way cuts against the inherent flexibility in the test. The respondent does not seek to impose any strict or inflexible rules in the assessment of what amounts to adequate consideration. And in my submission, the First Division should not be read as having sought to do so either. Lord Davidson did, of course, refer to the distinction which the First Division drew. And the First Division did draw a distinction between, on the one hand, a sale which occurs in the context of a company's need for liquidity in order to stave off a threat to its continuing in business, and on the other hand, a sale where the company's business has ceased or is about to cease. And in my submission, looked at in the generality, that is a perfectly valid distinction. I don't say that it's an inflexible rule, and I emphasise the word normally. That distinction can normally be drawn because that's precisely the word that the First Division used. And to take the former situation, one where the business is seeking to continue, it can readily be seen in such a situation that a company may require to sell assets at below market value in order to remain liquid and in order to continue trading. And in that event, it may be that the ability to continue trading may form part of the consideration and therefore will go towards the adequacy of the consideration. No doubt that will depend upon an assessment of all of the circumstances.
There are a number of things said by Lord Drummond Young that are capable of being construed in a rather less flexible way, but might be construed differently. For example, I wonder what you would make of the passage on page MS 84, where he says, 5 lines from the top, we're of opinion that the need for a forced sale to provide immediate liquidity is not normally a factor that should be taken into account in determining the adequacy of consideration. In any case, where the debtor has ceased business or is about to cease business. Now, I'm not quite sure, what does he mean by the words, or is about to cease business? I mean, one possibility is that one is looking at the matter with the benefit of hindsight and seeing, did he in fact cease business shortly after the transaction? But I presume that hindsight has nothing to do with this, except evidentially.
Yes.
Perhaps.
Yes.
Now, if the objective fact that he was in fact about to cease business, as matters turned out, isn't what this is talking about, are we talking about what's in the mind of the debtor? If so, how does that fit with the objective analysis that Lord Cullen was speaking about?
My respectful submission, if I may first emphasise the word there, insofar as the submission I'm making at the moment emphasises the flexibility in the test. In my submission, the first point to make, and I appreciate it's not, I think, precisely the point my Lord Reid is asking me, but I emphasise the word normally, because the first division in my respectful submission is making plain that while it is indicating circumstances in which that may be the case, it is normally the case. And I'll come on to make a submission as to positing examples in which one could envisage the contrary. In terms of what one is envisaging in order to bring about those circumstances which the first division envisages, in my submission, it must, consistently with what I have already said, be an objective test. It's looking to see what objectively one would have made of the circumstances at the time. And I think that the first division, when they come to look at the facts of this case, I think demonstrate that, because effectively what they were saying was that on any objective view, it must have been clear to the seller that the company was insolvent, they had sold the trucks, the principal asset was about to be sold, so on and so forth. And therefore, on any objective view of matters, the company, if it hadn't actually ceased trading, could not continue in any possible way to continue to trade.
And must have been clear to a reasonable purchaser.
Well, I suppose that, certainly I think the way in which Lord Drummond-Young expresses it as it would have been clear to the seller, on any view would have been clear to the reasonable purchaser. I mean, I think that probably shades into the point that Lord Davison made about the question of the certainty of the matter in the market. What is the purchaser of a property to make of that? A matter on which I intend to come on to. I'm happy to address it now, or I can address it in due course when I come to it.
The concern I feel about some of the things that are said here is that effectively they make distressed sales extremely dangerous from the point of view of any purchaser entering into such a transaction. And some of the things said could make life very difficult for anybody thinking about mounting a rescue of a Scottish company. They would encounter all sorts of risks, commercial risks, which they wouldn't face if they were south of the border. But it depends on what exactly you take the inner house as having meant. I mean, on the facts of this case, you might say that the circumstances objectively considered were such that it would have been clear to any reasonable parties in a position, he's using Lord Cullen's language, in the position of the purchaser and the seller, that this company was doomed, and that any attempt to keep it going by raising liquidity was hopeless, and therefore there was simply no justification for a distressed sale, no justification which could render the amount achieved on a distress sale adequate consideration. And that's one thing. If, on the other hand, what's said here would apply to what is a distress sale, and the company is aware of its own problems, but the situation isn't one where it would be obvious to a purchaser, then this could work in a very, not just an unfair way to purchasers, but in a way that would have public policy problems attendant on it as well.
Yes, well, I understand the distinction that your Lordship draws. In my respectful submission, on any view of the facts of this case, the matter fell into the former category on the facts. The question, I think, arises as to how one is to understand precisely what the first division meant. For my part, I had rather understood it to fall into the former category rather than the latter category. In other words, one would look to see the matter objectively as a whole, and it ought to be obvious in the circumstances. And essentially in these circumstances, which were, in my respectful submission, somewhat extreme, it would have been objectively clear to any party that the company simply could not continue in business.
Yes.
Did these rather prescriptive comments of the Inner House reflect your own submissions, Mr. McBrearty?
I'm not sure that I put them quite in that manner,
No.
my Lord.
No, they will.
I mean, your Lordship will appreciate that inherent in the submission that I am making to your Lordships today is an emphasis on the flexibility in the test.
Well, quite.
And therefore, I'm not sure that if I would give the clear answer, my Lord, I don't have the submissions before me that I made before the Inner House, and there would be quite wrong of me, I think, to give a definitive answer to that without checking back. But from my recollection is that I don't think I put it in quite such firm terms,
quite.
but it may have been that it was a reflection of Lord Drummond-Young's views on the matter rather than my own.
Can I ask you just while it's in my mind, I'm sorry this is taking you out of the order perhaps, but it's just while it's in my mind, at the end of the opinion of the Inner House, we're told that the safety valve is the discretionary nature of reduction. And I just wondered what you had to say about that. Section 242, subsection 4, which unfortunately the court hasn't been provided with copies of the section for some reason, but what it says is that on a challenge being brought under subsection 1, the court shall grant decree of reduction or for such restoration of property to the company's assets or other redress as may be appropriate. And I'm wondering if you can assist us on whether the granting of decree of reduction is in fact a matter of discretion under that provision.
My Lord, it's not a matter, of course, raised on the appellant's printed case. There is Inner House authority on the point, which I can direct your Lordships to.
Yes.
And the Inner House authority is to the effect that it is not discretionary in the true sense. In other words, that reduction or restoration of property is possible, it is mandatory. And the part of the section or such other redresses as possible is only directed at those circumstances where the primary remedy of reduction is impossible. So, for example, one might posit a situation where there's been an onward sale to a third party in good faith. And in those kind of circumstances, it would be impossible to reduce, and therefore one might have a conclusion for payment instead.
So insofar as there's any flexibility about this, it's not to be found in the nature of the remedy of reduction.
I accept that, at least on the Inner House's current interpretation of it.
Yeah.
Do you want your wish me to give the authorities for that?
Well, at some point that would be helpful.
Yes, I could do it now. The two cases, I think, Short's Trustees against Chung, 1991.
I think I was in that myself.
I noticed that, Lord. Short's Trustees against Chung, 1991, SLT, page 472. That's in the context of heritable property. The same observations are made by the Inner House in K's Trustees, that's K with a C, K's Trustees against K, 1998 session cases page 780. And that's in the context of restoration of a payment of a sum of money rather than heritable property. But the same point is made. I think there is also an Outer House decision of Lord Kingarth. If your lordship bears with me, I can obtain the citation for that. I think it's in the context of unfair preferences rather than in the context of gratuitous alienations. But of course, the same wording applies in section 243.
Yeah.
Could you just give me the year of the K case? I missed it.
Yep, my apologies, my lord. Yes, 1998.
Thank you.
Short's trustees went to the House of Lords, but I don't know if it went on, if that point was formed part of
Didn't go on that point, my lord. It went on the separate point on, from recollection, the question of whether one could register a decree of reduction.
Right.
Yes, it was about land registration.
Yes.
Which has now been subject, that's been reversed by way of statutory provision. Now one can, as your lordships will be, I think, section 46A of the Conveyancing Scotland Act, 1920. I can't remember the precise year of that. But, no, I accept that. Of course, as your lordships, I think, will be aware, there have been certain cases, certainly at an Outer House level, brought to challenge that. But as things stand, that is the state of play on the Inner Houses.
Thank you.
So do you submit or accept that the requirement to have regard to the circumstances would admit a view about what a reasonable purchaser in the position of the actual purchaser might have known or be expected to find out by some process of due diligence about the level of distress of the company?
Yes, I would accept that, my lord. In other words, the flexibility of the test permits of, if one looks at an objective test and one looks at the circumstances of the company and one is considering it the purchaser as well as the seller, then yes, in my submission, what would reasonably be available is a matter that ought to be, or at least on any set of given circumstances, might be taken into account, if I could put it that way. Before I forget, if I might just mention the Outer House case, Lord Kingarth, is the case of Bailey Marshall Limited against Avian, A-V-I-A-N Communications. And that's reported at 2002 Scots Law Times, page 189. Can I assist any further with that particular
Thank you very
line
much
of
indeed,
inquiry
Mr.
just now?
Thank you, Mr. McBurty.
If I might, I think come back to where I was, which was discussing the distinction between circumstances where a company might be able to continue to trade, subject to these observations about what might be known to the purchaser, and circumstances where it's plain that the company cannot cease to trade. And in my submission, if one looks at that in the generality without setting a fixed rule about it, there is plainly a logic to the distinction between those two sets of circumstances. In other words, if a company can continue to trade, it is perfectly open to the defender, the recipient of the property, to set forth a defence that says they required liquidity, they needed to continue to trade, and therefore if they establish that as a matter of fact, it may transpire on the particular circumstances that the part of the consideration was the right to continue trading. And for what it's worth, your lordships will see within the bundle a case in which effectively that was established. That's the case of John E. Ray, Electrical Services Linlithgow Limited against Lord Advocate. It's to be found at Volume 1, Tab 4. It starts at MS 301. And I think in particular it deals with the point at MS 304. And I think it's a case which my Lord Hodge may be
I recall it.
familiar with. But one sees Lord Sutherland's comment in the left-hand column at letter E, As far as the adequacy of consideration is concerned, I am of the opinion that one cannot look simply at the issue of the first short certificate. Again, looking at the agreement as a whole, the basis was that provided electrical services made monthly payments, they would be entitled to renewal of the certificate. And putting this in context, this was a certificate from the revenue which entitled them to trade without deductions being made at source by their employers when they were acting as a contractor or subcontractor. I am satisfied that without the certificate, electrical services could not have continued trading and would have been forced into liquidation in 1986. As things turned out, the right to continue trading was not a particularly valuable one, as eventually electrical services made substantial losses and were subsequently forced into liquidation as a result. The position, however, must be looked at the time when the agreement was entered into, and not in the light of subsequent events. The effect of granting the bond, therefore, was to stave off the imminent demise of the company, and it is difficult to imagine a more valuable consideration than that. So one sees a practical example there of circumstances in which the defender was indeed able to establish that the need or the right to continue trading was indeed formed part of the consideration. I didn't mean any disrespect, of course, by not mentioning Lord Davidson as having been involved in the same case.
Yes, we've met before on the issue of adequate consideration.
And who won?
I did.
It wouldn't befit me to make mention of that circumstances. By contrast, if it is the position objectively that the company can no longer continue to trade, it follows that there will not normally be any urgent reason for it to sell its assets. If the company is bound to cease trading, it follows that normally the urgent need for liquidity simply disappears.
Well, that may depend on the attitude of the secured creditor, might it?
I appreciate that, my lord, and again,
Who, depending on his margin of comfort or cushion, may be actually, once the income stops flowing in to service the mortgage, be determined to act pretty fast.
That's certainly true.
I'm not making any assumptions. It will be a factual question in each case.
I entirely accept that, my lord. Again, if I might emphasise the word that I have used repeatedly, is normally. Yeah. In other words, I'm not seeking to establish or set any fixed rule about this. One can always posit examples in which the contrary would be the case, and I entirely accept that. And indeed, I think in the printed case, examples are given of other circumstances in which it's recognised that there may very well be other circumstances in which the company may not be able to continue to trade without, on any objective view. They may enter into a sale below market value, and yet there are good circumstances which would justify that as being adequate consideration.
Yes, I mean, it seems from Lord Woolman's judgment that the case that you were facing was one that this was a fight for survival. And by the time it got to the inner house, it seemed to be apparent that survival wasn't on anyone's minds. It was, in effect, an informal winding up of the business.
Quite so, my lord. I think the submission that was made on behalf of the defender at the end of the proof was a fight for survival, as I'll come on to indicate. That was what was accepted by Lord Woolman. Yes. When one comes to the objective facts, the division, in effect, said, no, that couldn't possibly have been the case. And for what it's worth, it's now, I think, a matter of agreement in the statement of facts and issues that the business could not continue.
Yeah. But you might have faced a case, which I think Lord Briggs is adverting to, that the secured creditor might have wished to realise the property and could either have done it itself or could have consented to a liquidator doing it. Yeah. You might have faced a case saying that expert evidence that this would have cost X, Y, and Z, and therefore in the circumstance the differential between that going down that route and the price obtained was sufficiently small that it amounted to adequate consideration, but that wasn't how it was pleaded.
No, quite so, my lord. And I'm coming on to, I think, address what the specific case was that was faced by the pursuers and what the finding was of the Lord Ordinary and why that was, in any view, wrong. So that's quite so. Just to pick up on the example, again, in the abstract, of course, one could posit circumstances where, for example, perishable goods, where the company simply cannot continue. For example, it holds salmon worth £100,000 on Monday and chooses to sell it at £50,000 because by Friday it will be worth nothing. But the underlying principle in those circumstances, at least on that set of facts, would be that it would be acting in accordance with the interest of the general body of creditors, because it would be achieving a price that otherwise simply would not be achieved in due course. So there are many circumstances in which one could posit the alternative, and the simple point is that made in the normal course of events, the ceasing of the business would tend to indicate no urgency for the sale. So I say that it's a flexible position, and in my submission, one takes that viewpoint and one takes an objective standpoint as to whether or not the business can continue to trade, can continue to work. In my submission, it is an approach which is perfectly workable. There is no merit in my respectful submission to the suggestion that this is simply unworkable in practice from the perspective of the purchaser. And the purchaser, again, and in saying this, I don't detract from the point that my Lord Reid and the Chair made to me, which is that should it be objective and the risk of going too far? Well, I recognise that, but equally taking the point I think that my Lord Briggs raised, well, what should the reasonable purchaser be able to ascertain in the circumstances? And if one looks at it from that perspective, well, one has to take account, in my respectful submission, that a purchaser is acting in the market, and there are certain steps on any given set of circumstances that one would expect a reasonable purchaser to take objectively in order to ascertain what the state of play is, or at least, let me put it another way, certain objective facts which one would expect the reasonable purchaser to be aware of or to make himself aware of. And if
yes, but when you're negotiating at arm's length and you think the price is low, you don't want to go to the vendor and say, why on earth are you selling at such a snip? I mean, it's not something that one would do in the market.
No.
So you'd have to investigate in another way then.
Yeah, there may be other steps to be taken, and again, it may depend upon the facts of the particular case, but it may be that it's focused on the particular facts of this case, because on any objective view in my submission, it was plain that this business was not continuing. That is essentially the point that I make regarding the workability, if you like, of the test. If I might turn just to, there's repeated mention of the facts of this case, and if I might turn to say something about the proper approach on the facts of this case, and to some extent that involves, I think, looking to what, in my respectful submission, Lord Woolman's error was at first instance. And I mention that because, of course, although Lord Davidson didn't expressly mention this morning, I think your lordships also have his position in writing on the appellate jurisdiction and whether or not in their house the First Division ought to have interfered with the first instance decision at all. The essential point that I make is, and it ties in with the discussion thus far, is that the appellant, in seeking to make out the defence of adequate consideration, sought really to rely upon one factor only, which was that the financial distress of the company was such that it necessitated an urgent sale. But when one looks to the evidence that was adduced in favour of that, in support of that defence, there was no real suggestion that the company could continue to trade. But it was that urgency, and effectively expressed through the concern about the building up of arrears, which is what was said to justify a below-market sale. It was all about the urgency in these distressed circumstances. And I emphasise, and so far as it's relevant when one comes to consider the appellate jurisdiction point, that this is an exercise before the Lord Ordinary which was conducted, in this respect at least, on paper. The only oral evidence that the Lord Ordinary heard was the evidence of the expert surveyors. Otherwise, parties entered into a joint minute which set out an agreed set of facts. Your lordships have that at the appendix at tab 9. I think we've already looked at that. MS 104. I don't require to take your lordships to it. And beyond that, the appellant relied upon certain witness statements which were agreed as being equivalent to oral evidence. And in particular, the statements of the seller and the purchaser, directors of the two parties. Those two statements are found at MS 109 and MS 111, respectively. They're perhaps notable for their brevity, and it is plain in particular from the evidence of Mr. Quinn, the director of the seller, that he saw the key to the price being obtained as being the urgent need to avoid falling further into arrears. And I emphasise that the commercial judge did not have the benefit of seeing or hearing those witnesses. He simply read their statement in the same way as the division did. And that was the only substantive reason advanced to justify a price, the price being adequate consideration. The appellant did not rely upon, for example, as my Lord Hodge mentions, particular costs which were arising in relation to rates or penalty, interest or anything of that nature in order to, in effect, narrow the gap between the market value and the price which was actually achieved. It did not rely upon anything in connection with the heritable creditor. It did not suggest that the liquidator would be bound to only obtain something which was less than market value. It simply relied upon the urgency given the arrears. Now,
we read in paragraph 30 of the Lord Ordinary's opinion, the company could not afford the leisure of a lengthy marketing period. Now that is a finding of fact by the judge entrusted to find the facts. What do you say about that? How do you escape from its coils?
it was wrong. And I use very pointedly the word that I think my Lord Wilson prefers, and I leave out the adverb plainly. But in my respectful submission, it doesn't matter one describes it as plainly wrong, a decision that no reasonable judge could have taken, a decision that was not open to him. I think a phrase that my Lord Wilson once upon a time favoured but has moved away from. All of these, it is in effect a wrong decision. If I were to put it another way, we are not in circumstances where what was open to the Lord Ordinary on the evidence was a range of decisions. The only decision that was available to him on the evidence was that the company could not continue to trade. And that is effectively what he overlooked. In my respectful submission, that is what the Lord Ordinary overlooked. One sees his reasoning at paragraph 30 onwards, and in particular, my Lord Wilson's highlighted that part. Before paragraph 30, in paragraph 30, he says, Grampian had very limited options. It was in a perilous financial position. It could not afford the leisure of a lengthy marketing period. And at 31, Carnbroe's offer presented an opportunity to obtain a quick sale.
Can you help me? The one thing about which the two witnesses, in fact, Mr. Quinn and Mr. Gaffney, appeared to agree is that it was the risk of repossession that was primarily in the company's mind, the company's corporate mind. What is the duty of a Scottish mortgagee when selling the property pursuant to its power to do so under the mortgage, or whatever the, I'm sorry, I'm using an English word which may be entirely inappropriate.
I think if I understand your Lordship's question correctly,
In terms of the price to be obtained.
Section 25, I think, of the Conveyancing and Feudal Reform, Scotland Act 1970, I think, contains the answer. And if your Lordship bears with me a minute, I should be able to give him the precise wording, I hope. Sorry, my Lord, it's somewhat more elusive in my notes than I thought it was. Essentially, it's best price that can be reasonably obtained.
Best price reasonably available.
Reasonably obtained.
And is he under any obligation as to the timing? In other words, if you can only get the best price by a sale marketing period of, say, 2 years, is he expected to take 2 years, or can he decide to sell in a much quicker period?
I think there's any specific provision as to the timescale. Yes, apologies, my Lord, I have found it. Can be exercised either by private bargain or by exposure to sale, and in either event, it shall be the duty of the creditor to advertise the sale and to take all reasonable steps to ensure that the price at which all or any of the subjects are sold is the best that can be reasonably obtained.
Yeah.
And that would be an obligation, a duty owed to the owner of the property who's granted the security.
Yeah.
I query, my Lord, in response to that, I query whether that may be a duty owed in the wider sense to other creditors, because of course there's the possibility of the sale achieving a price greater than the remaining
Yes.
outstanding loan, and
In
therefore...
which case it would go back to the company.
It would go
and,
back
and
to
the
the
company in turn, the directors of the company in the event of insolvency, their duty to the company would encompass a duty to the creditors.
Yes.
Rather than, I can't think of any case where a creditor has pleaded that section against a standard security order, or are there such cases?
Can't think of any off the top. Your Lordship may be right. I mean, the practical result is, of course, that the sale at best price that could be reasonably obtained will benefit, of course, the grantor of the standard security, together with any excess going for the benefit of the general body of creditors. In any event, the point about the error, if I may say, the wrong decision by the judge at first instance, was that he simply did not take account of the evidence which pointed to the conclusion that the company could not continue.
But that doesn't seem to have been anybody's case. I quite see that as a matter of principle, you can say that Lord Cullen's test requires the adequacy of the consideration to be assessed in the circumstances. And you could say that the judge failed to have regard to a relevant circumstance, namely the hopelessness of the company's position. But the hopelessness of its position is an inference being drawn from evidence. Nobody gave evidence that its position was actually hopeless, and it was so hopeless that it would be apparent to any reasonable observer in the position of the parties that it was doomed. And nobody gave evidence that that was their understanding. Does he err in failing to take that into account if nobody's asking him to take it into account?
I think the point in that respect, my lord, is that it comes back to one of my preliminary observations. The onus is on the defender, the appellant. The appellant must set forth his case. The liquidator has done all that he needs do in order to establish the case. It is over to the defender.
Well, the defender says the arrears owing to the bank were mounting up. I needed to raise some cash in order to clear the bank loan, and so that's why I sold the property under the circumstances in which I did, and I got a fair price given those circumstances.
And I think the answer to that becomes, well, objectively, that was undoubtedly the subjective view of the seller. When one looks to his statement, that was his subjective view. The Lord Ordinary accepted his subjective view. Yeah. And the point that I make, well, let me say first what the division did. The first division looked as, in my submission, they were perfectly entitled to do, because the Lord Ordinary had carried out a paper exercise. He'd not heard any nuances of the evidence. He'd not heard assessed credibility or reliability. And they carried out the same exercise and looked at the same statements and the same agreed joint minute. And they looked at it and said, that is not open to the judge, because effectively what he has done is to miss out of that assessment the various factors which point to the inevitable conclusion that this business could not continue. Therefore, insofar as the appellant had rested its case on urgency, urgency was not demonstrated.
Well, they're making a finding of fact which he didn't make and wasn't invited to make.
Regarding urgency?
Regarding the viability of the business.
Well, I think, respectfully, I'm not sure that I would have to check, but I'm not sure viability of the business featured in the pleadings at the outset. It was a submission that was made, but the fact of the matter is there was none of the evidence supported it. And again, if that's what falls down, the absence of a factual finding on that, well, the onus is on the defender. And the onus hasn't established viability of the fact, a viability of the business as a fact supporting urgency as a factor justifying the reduction in the price. I mean, what I recognise, if I put it this way, Lords, of course, if I've taken my starting point here as being that it's an inherently flexible test, it's an open textured phrase, adequate consideration, then I must recognise that there will be many circumstances in which the question of whether the consideration is adequate will indeed turn upon the precise facts. And whether one considers this to be adequate consideration ultimately to be an evaluation or a question of mixed question of fact and law, a great deal will depend upon the facts. And therefore, if there's a genuine dispute between the witnesses which bears upon the adequacy of the consideration, then I would recognise that the appellate court should exercise a degree of caution before interfering with that decision. But in my submission on these facts, if one looks to the Lord Ordinary at paragraph in particular 30 and 31, the conclusion that he reached was that there was urgency. What he did not mention was the remainder of the evidence, which was plain on the basis of the agreed facts and on the agreed statements, that the business could not continue. Now,
He was responding to Mr. Sanders' case that Grampian was fighting for its survival, and that seems to me the only explanation that one could have a finding that it couldn't afford the leisure of a lengthy marketing period.
Yeah.
And in your case, presumably, is that if you read probably the most important statement, which is for objective fact, which is that of Mr. Quinn, there is no evidence that the company was fighting for its survival.
That's precisely my point, Lord, and I think my Lord Hodge has put it.
But it might be said that there was evidence from both Mr. Quinn and Mr. Gaffney that they couldn't afford a leisurely sales period because the mortgagee would take possession.
One looks to that situation and one still queries that does not, in my submission, my Lord, go far enough to justify an urgency to a sale where the alternative would be necessary. You
would presumably say that that's not enough. You have to show A, that there be repossession, and B, that a sale by a mortgagee in possession would produce a lower price.
The case as to what the mortgagee in possession would get or the liquidator would get was never made.
Yeah.
No. In other words, one would have to demonstrate on behalf of the defender that on those particular circumstances, there would inevitably have been a lowering of the price. And we're simply not in that territory because of the very restricted nature of the defence which was put. And essentially then, the Lord Ordinary, in my submission, was wrong for those reasons.
But Mr. McBrearty, these questions, was the business then viable? Was the business not then viable? How urgent was it? What would have happened if there'd been no sale to the appellant? I mean, all these points, according to Lord Davidson, are rather overridden by your expert going into the witness box and saying that he wouldn't have raised an eyebrow at the price that was agreed. What do you say about that?
I think the observation, my Lord, that was made by the division was that when one looks in context at the whole of Lord Woolman's opinion, it is plain that observation was being made in the context of a forced sale, would not have raised an eyebrow in the context of a forced sale. In other words, it simply brings one back to saying, well, was that justified in the circumstances? Did the urgency justify the below market sale? The raising of the eyebrow must be understood in that context, my Lord. This was not, in other words, in my respectful submission, it wouldn't make sense otherwise because he had already given his evidence that the market value was £820,000. And therefore, the fact that it wouldn't raise an eyebrow must be seen in the context of a forced sale. In other words, a restricted period of marketing. So, essentially, on the what I come to say about the error that is made there, in my submission, essentially answers the substance on the facts of this case, because there was simply no basis for there being an urgent sale. And of course, I emphasise once again that I don't say that there can never be a below market value sale when a business cannot continue, but what the Lord Ordinary simply did not address in accepting the submissions for the defender was he simply did not accept that the business could not continue. And again, the division, paragraphs 27 to 29, in my submission, properly assessed those factors which demonstrated objectively that the business could not continue. I emphasise that it is now accepted as a matter of fact by the appellant that the business could not continue. That's to be found at paragraph 12 of the Statement of Facts and Issues, MS 28 to 29. So what was inferred by the First Division, and sorry, paragraph 27 to 29 is at MS 85 to 87. The division inferred that it could not continue on the basis of the severe financial difficulty, the insolvency, the selling of the trucks of the distribution business, which on any view might have made things a little tricky, and the selling of the principal place of business and effectively the last asset, in effect. The division inferred that the business could not continue. That's not now in dispute. The division, in my respectful submission, were quite right to infer that. The Lord Ordinary, by contrast, was quite wrong to ignore that. And that's where his error lies, answers my Lord's question. And, of course, I emphasise that the fact that the business could not continue, well, the appellants could have gone further. They could have pled and relied upon any number of other facts that might have permitted them to say that nevertheless, despite the fact that it could not continue, there are other facts which would justify the adequacy of the consideration. They didn't do so. It was effectively a very simple submission about urgency and no more than that. So in my submission, the substance of the appeal is dealt with by that submission, and the question of appellate jurisdiction, because we are not in the territory, in my respectful submission, of there being more than one available option on the evidence which was before the Lord Ordinary. It was effectively one conclusion only, and for that reason, the First Division quite properly interfered.
Can I ask you again about things said by the Inner House? Going back to MS 84, we looked earlier at paragraph 25, but if we look at paragraph 26, it begins by saying that the foregoing discussion applies if cessation of business is expressly contemplated, but in many cases it will be apparent that the business can't continue following the sale. It says, in such a case, the court must scrutinise the company's commercial situation in order to determine how realistic the possibility of continued trading may be. And again, over the page, in all 4 lines down, in all such cases, we consider that the court should examine the information that is available about the business to determine whether the business as a whole or the remaining part of the business is realistically viable. The same point as before that concerns me. Where does the this looks like an ex post facto examination by the court of what it assesses the situation to have been, rather than considering whether, in the circumstances, I presume, perhaps not as known to the parties, but perhaps as they would have been known to reasonable parties, reasonable persons in the position of the parties at the time, they were.
I think the key is that it may be that in that, I need to just check it, but it may be in that particular paragraph that the Lord Drummond-Young hasn't actually used there at that point the word objective. But I have to find the reference, but certainly key, it respectfully seems to me, to his overall analysis was to take one of the starting points consistent with one of my preliminary observations, that the test implies an objective standpoint. And if one takes that starting standpoint, then one could readily see that what we're concerned with in this particular part of the consideration is an objective standpoint of what would reasonably be known to the parties. Subject to the query, and I think, again, picking up a point that my Lord Briggs made earlier, is that what would reasonably be known or ought to have been known to the parties. In other words, it would take account not just of what they would reasonably know, but what they reasonably ought to have found out in those circumstances.
And you presumably say that in the context of the rigours of this statutory provision, someone buying substantial property from a company in extremis at what might at first sight appear to be well below open market value may need to carry out some due diligence to protect himself and to satisfy himself that he can prove, if push comes to shove, that the circumstances were such as to justify that departure. And
a very good example of this is again, the particular facts here, because It's worth bearing in mind that although by the time the matter came to proof, the difference between the surveyors was between the figure of 740 and 820,000 pounds. Curiously, the actual valuation report, which was held by the purchaser and the seller at the actual time, was a value of 1.2 million pounds, reducing to 800,000 pounds with a restricted period of 6 months marketing. So the reasonable purchaser, taking that merely as an example, knows immediately that they are looking at a consideration which is very considerably below market value.
Yeah.
And that is bound to inform the need for them to satisfy themselves or to consider whether they, depending on what they're able to ascertain, whether they take the risk or they don't take the risk.
But I mean, it does seem quite a curious thing, as my Lord Hodge says. If you're the purchaser and it seems to be a low price, you're not going to go in and probe around in a way that might drive it up. If you're the vendor, you're not going to go in proffering all sorts of information which will make the purchaser think, oh, I can get away with a much lower bid because they're in difficulties. So insofar as one's looking at it objectively, it just seemed a little bit strange that you're constructing something on the basis that wouldn't actually happen in reality. Could I ask a question? Because I've just been puzzling about the way section 2424 works, and it's the proviso at the end. It says, provided that this subsection is without prejudice to any right or interest acquired in good faith and for value from or through the transferee in the alienation. So suppose that the adequate consideration was going to be 800,000, but the purchaser paid 500,000. So it is an acquisition at an undervalue. Is the purchaser protected to the extent of the £500,000 that he's paid?
No.
No, that's what I wanted to understand.
No, sorry, might I be clear? My apologies.
I'm so sorry. Yeah, you're trying to find the provision.
Sales looking at.
Yeah, it's the proviso.
Provided that the subsection is without prejudice.
Yes, I just wanted to understand how that's.
No, but if the purchaser sells it on or borrows on security of it, then the purchaser from him or the lender on the security is protected.
I see, from or through the transferee. Yes, I see.
Yes,
Reed's answered the point.
And in this case, the Bank of Scotland was alerted by the disparity and did make inquiry, but seems to have been satisfied by a short email.
Indeed, my lord.
Okay, so going back to my question then, the protection for the purchaser is not through that proviso, but has to be through the concept of what counts as adequate consideration.
Yeah.
Yes, subject to any claim that they might have ultimately in the liquidation if there is reduction.
Right. All right, thank you.
Yes, that's really been the point behind my questions, because once you eliminate reduction as offering any safeguard, then on the inner houses approach, if the purchaser's assessment is wrong as to prospects of the company, then it seems that he's at risk of losing his money.
I think the answer comes back to this, my lord, that of course, if one applies an objective approach, one cannot lose sight either of the purpose of the section, which is the protection of creditors. That's the purpose of the section. And it would be odd, in my respectful submission, if one were to interpret it in a way that put the balance all in the favour of the purchaser, where one sees the whole purpose lying behind it. And in fact, the general principle of falling upon insolvency, the company being required to manage its assets in a way that is for the benefit of the general body of creditors.
Well, it only comes under that duty in insolvency, but we're talking about a period of up to 2 years prior to insolvency.
It's prior to the insolvency process, but if the company is balance sheet solvent at the time, then the section is applied by subsection 4A.
Yeah, A. Yes, you're right.
I'm grateful to my Lord Briggs. I think that was the point I was about to make. In other words, it's
sorry.
not insolvency process. No, I'm grateful. It's not insolvency process, but from insolvency onwards.
But Mr. McBride, the inner house puts everything on the fact this business was doomed anyway when this transfer was made. That's the case you're making. The difficulty for us is we don't see, as the President of the Court has said, we don't see any reference to this in Lord Woolman's opinion. We have no sensation as to the extent to which Mozoa made this point, and we have no sensation about the response to it that might have been made if it was made by Mozoa. So it's difficult.
My respectful submission, it ought not to be difficult, and for this simple reason, which is that, in effect, it was a paper exercise, and the division carried out the same paper exercise, and what they identified was an error, a clear error of failing to take into account that. And if there was an omission, in other words, if what it comes down to is an omission of the Lord Ordinary in dealing with the question of whether there was genuinely a fight for survival and so on, well, the onus is on the defender. The onus is on the defender. In other words, if your lordships are genuinely find that to be a difficult question, the problem lies with the appellant and not with the respondent. But in my submission, one needn't.
Well, it's a legal onus. If for example, he says what he did say here, that might be sufficient to discharge the legal onus on him. The counter-argument that could have been made was, well, that's all very well, but the business was doomed in any event. So trying to, whether or not there was going to, you could stave off repossession, didn't, whether or not you were getting the same as you would have got in a repossession was really beside the point. But the argument that it was, the business was no longer viable just wasn't raised. As far as I can
bear
see.
with me just for one moment. I think in the outer house, it was, if I were to put it this way, in the outer house, the defence that was raised was to the extent reflected in Mr. Quinn's statement. In other words, nothing is said in Mr. Quinn's statement about the viability of the business. And one can see that. And in particular, unless your lordships wish me to take them through, I don't intend to, but Mr. Quinn's statement is to be found, I think, at MS 111. And in particular, I direct your lordships to paragraphs 2, 3, 6, 9, 10 and 11.
We don't, I think, have the pleadings, do we?
Excuse me, my lord?
I don't think we have the pleadings in the case, do we?
We don't have the pleadings in it, regret, my lord. But they...
I mean, to everybody's knowledge at the time, presumably including Mr. Gaffney's, the company had sold its lorries. It was a distribution company. Therefore, the essential sinews of its business were somewhere to put the goods between point A and point C, and a fleet of lorries in which to cart them around. If you'd sold the lorries and sold the depot, I mean, it seems to me that the common perception of both sides to the transaction, and for that matter, all the courts that have looked at this case, would be that there was no continuing business once the depot had been sold. There might be some completely different business, but certainly the company's existing business wasn't going to continue.
And that is effectively what the Lord... If I'm to trace back, and I do apologise if I'm being repetitive, your lordships will no doubt stop me when they tire of my repetition. But I draw back to Mr. Quinn's statement, set out the objective facts upon which he considered that there was urgency. There was nothing in that statement about the viability of the business. The submission was made at the end of the proof, as recorded in paragraph 29 of the Lord Ordinary's opinion, that they were fighting for their survival. With the greatest of respect, it seems to me that when one looks to Mr. Quinn's statement, there was no factual basis upon which that could have been concluded. And that was the conclusion that the First Division drew, relying upon precisely the same material and bearing in mind that the Lord Ordinary had no advantage whatsoever over the division, because he hadn't seen or heard any evidence at all in relation to this matter. He'd heard the surveyors, but he hadn't heard the evidence from Mr. Quinn or Mr. Gaffney. So the division were carrying out the same paper exercise in its entirety, and at paragraphs 27 to 29 of the opinion, what they draw to the reader's attention is four facts on the basis of the printed evidence from which they concluded that the business could not continue. The severe financial difficulty at the time of the disposition, the fact that in conjunction with that, cash flow had collapsed, in the words of Mr. Quinn. The company was insolvent on a balance sheet basis. The trucks had been sold. It's a distribution company. It has nothing with which to distribute anything. And fourth, it was selling its place of business.
But it's not just whether the business was then or was not then viable. It is what is now said about the legal consequences of its not being viable. What is now said about the fact that there's no conceivable need for a forced sale here because the business was not viable. And what worries me, speaking for myself, is, was this fairly raised?
Yeah.
So that it could be dealt with, if it can be dealt with.
Start again, my lord. The onus was on the defender. The evidence which the defender adduced in support of its case and there being adequate consideration is the joint minute of admissions, Mr. Gaffney's statement, Mr. Quinn's statement. On this point, it was for the defender to demonstrate. So if viability of the business formed a part of its case that there was adequate consideration, it was on the appellant to raise that. The appellant didn't do so. There's nothing in those statements, and that was effectively the First Division's conclusion. Not simply that they drew from those four factors that I've mentioned at paragraphs 27 to 29 that there was no urgency, but implicit in what they're saying there, that there was nothing to the contrary. In other words, the First Division didn't find themselves looking at matters and reweighing and saying, well, appreciate there may be this factor, but we weigh that in the balance and we come to a different conclusion. They were saying that you look at those four factors and one looks to Mr. Quinn's statement and the absence of anything that would support the viability of the business, there was nothing. And the defender required to adduce that evidence and didn't do so. And I emphasise again that at this stage removed, of course, we now see it's accepted. The business could not continue. The appellant accepts that. And so it rather seems, with respect, that once one accepts that the appellant themselves say that the business could not continue, the First Division's conclusion was justified. The Lord Ordinary's conclusion was not justified. I fear that I will be repeating myself if I to go over that ground, so I'll stop there unless I can be of any further assistance in relation to those points. If I might raise one last point, my lords, and it's really just the very last argument that the respondent raises, and that's the question about another matter upon which the onus falls on the appellant, which is in relation to the overall bona fides of the transaction. In other words, they must establish, as part of the adequacy of the consideration, they must establish the adequacy by reference to value. They must also establish bona fides. And this has also been raised in a different context, I think, in the appellant's printed case, because the appellant, I think, urges on your lordship's suggestion that they should look to see whether the transaction as a whole appeared commercial. Now, that may not be a helpful shorthand, but if one looks at the agreed facts in my submission, there are a number of startling facts about the transaction which point away from the conclusion that there was bona fides. And in particular, I rely upon the first fact being that the disposition and registration of the property were both concluded prior to any exchange of money. In other words, and your lordships will find that in the Statement of Facts and Issues, also in paragraph 1 of the divisions. In other words, on the 24th and 25th of July, one sees a disposition and the registration of that, no money in exchange. In respect, it seems to me that that is not usual commercial conduct.
Well, but if you're going to run an argument to that effect at the proof, do you not have to put it to the witness?
Well, I take your lordship's point. The sum total of that argument can only be, my lord, that the onus is on the appellant, and therefore, if there are oddities about the transaction not explained by the appellant, it's a matter of onus, and I go no further than that, because I recognise the force of what my lord says. The second point, for its worth, the main principal point on which I draw your lord's attention, is the one that I think my lord Wilson raised, which was the fact that the payment at the time, well, in fact, I say at the time, a month after the disposition, on the 18th of August, the sum that was paid was £473,000 direct to the lender, with no balance being paid of the remaining sum of £73,000 until after the proof was heard in this case. Again, commercial conduct might be queried, all against the background of the relationship between the seller and the purchaser, and so on. I raise it for what it's worth, but I make the point that it is a matter of onus, again, that runs through the overall position for the defender. Unless I could be of any further assistance, if your lordships would just... Unless I could be of any further assistance, I simply move your lordships to refuse the appeal.
Thank you very much, Mr. McBrearty. Ms. Ower? Thank you. Lord Davison.
I'll make only one point. The respondents cannot and do not challenge the evidence in relation to the expert views in terms of valuation. The price is £550. The experts, when they take account of a 6-month marketing period, place £650 within the acceptable range. So all the business about background and the way that one might look at Mr. Gaffney and Mr. Quinn is neither here nor there when one has that objective fact. With that point, I have nothing further to add.
Thank you very much. Well, we're grateful to counsel for their very economical and clear submissions. We'll take time to consider them and give you our decision in due course.